Tuesday afternoon is we're going to talk judicial branch really quick, hopefully in 20 minutes or less. Okay, so getting into that right away, we're going to start with the Supreme Court. Supreme Court is the only court discussed in the Constitution and talking about an independent judiciary. So we'll get into terms and how federal judges and Supreme Court justices, how they get their job. So again, when we say federal judiciary, we are referring to any federal court, whether it's a federal district court, like what you might see on the show Law and Order, or a federal circuit court, or ultimately the Supreme Court. The role of our courts is to interpret what the law means. The only court discussed in the Constitution is the Supreme Court of the United States, and it in fact is the highest court in the United States. The Supreme Court primarily acts as what's called an appeals court. So when you think of an appeals court, think that you're watching NFL football on a Sunday, and there is the great question as to what constitutes a catch, and they go to the video review, and that video review is ultimately kind of the same function the Supreme Court holds, is they are going to determine if there was any type of wrongdoing, and once that decision is made, it can't be reviewed again until there is a similar circumstance that comes up. So anyways, we'll come back to that after a little bit. But if you understand that our Supreme Court is the highest court in the United States, you'll be in good shape. Federal judges at the federal level, they are not elected. They are appointed by the president, confirmed by the Senate, and they serve a life term, which means they serve until they die, resign, get impeached, retire, whatever. And the reason we do that is to take some pressure off the justices and to try to make our judicial branch free of politics, which is a really hard thing to do, and there's still politics involved with the judicial branch, but we will, again, something we'll come back to here after a second. We'll also come back to Fed 78, which is our last of our Federalist papers that we have to know. And that's a Hamilton paper where we have the quote that the judicial branch is the least dangerous to the political rights of the Constitution. His big thoughts for why that was because they don't make laws. They simply just interpret. That's what the court does. And over the course of time, our Supreme Court and our court system has become a lot more powerful. So again, reasons for why we have what is called an independent judiciary, and what that means is we're looking for a judicial branch that is free of politics. And that's why judges receive a life term, and that's why their salaries are protected. So in the event that a judge maybe makes a decision that is not popular with the public, they can't be voted out. Again, that judge is simply reviewing based on their interpretation of the Constitution and ultimately what the law means. And so in keeping an independent judiciary, unlike something like Congress, where if Congress makes unpopular laws, there's a chance that those representatives, those senators might lose their job, or if a president makes an unpopular decision, there's a chance that that person can be voted out. Judges don't face that. Judges, again, because they serve that life term, their job is simply to interpret the Constitution on the basis of their own opinion. And again, they are appointed. Federal judges, including Supreme Court justices, are appointed by the president, confirmed by the state. At the state level, those elections that's exactly what they are, is they are elections. They get voted in. So like we think of the famous, now honorable Nick Thornton. He was elected by the Southeastern Judicial District in North Dakota, which again kind of changes things a little bit, but that's something that's a little bit beyond our scope for now. So again, understand what judicial independence means, and that our judges simply are to rule on the Constitution based on their interpretation of the law. Now, getting into where this becomes kind of a political process is presidents, when they appoint a federal judge or a Supreme Court justice, they're going to appoint somebody who has that has an interpretation of the Constitution that might be similar to theirs. So a Democrat president is going to oftentimes appoint a more quote-unquote liberal judge, even though they will never have to identify their political party as a part of their judgeship. Somebody that's going to rule on laws in what they believe will be a way that kind of lines up with their thought process. So here it kind of just runs through Supreme Court Associate Justice Sonia Sotomayor. She was appointed by the Obama administration back in 2009. Again, our Constitution does not talk about or state any formal qualifications to serve as a judge, but our Supreme Court justices are oftentimes people who have been judges in a lower court. They have vast knowledge of the law, that type of thing. And again, when we start saying that these are appointments and that to be confirmed by the Senate will hold these hearings, and they'll check the qualifications of judges, so to speak, and really they kind of just bring them before the crowd and I don't know, ask them questions that may or may not be relevant, trying to get a grasp on how they might interpret the Constitution. Okay, so it does kind of become a political process in the sense that um, the party politics of the Senate kind of play a role in appointments, and there have been judges that have not received their appointment. That has very much been a thing. Okay, so that's kind of our first section. Getting into what our Constitution says about our court system, and Article 3 is where you would find that information. It's a very short article. One of the shortest articles in the Constitution basically says we have a Supreme Court, and that's it. It says that our Supreme Court is the highest court in the land. Now, primarily in modern times and overall over the course of history, the Supreme Court has acted as an appeals court, or they've held appellate jurisdiction. Again, basically meaning that they have the authority to review a case of a lower court if they so choose. Appellate courts, whether it's the Supreme Court of the United States, the North Dakota Supreme Court, a federal circuit court, they get to pick and choose what cases they hear. Unlike a federal district court that oftentimes holds what's called original jurisdiction, where it's like a trial, right? You think of the show Law and Order, people get brought in for accusations of crimes, there's a trial, there's witnesses, so on and so forth. With an appellate court, you don't have that. You just have two sides. You have the appellate, the person appealing or the party appealing, and the respondent. So you have either the person appealing, sometimes called the appellant, or the petitioner, and you have the respondent, the person responding to the appeal. Our Supreme Court primarily acts as an appellate court. They review cases mostly coming from lower courts. Now, the Supreme Court does have the ability to hold original jurisdiction in cases where the United States is the party, cases involving ambassadors. If there's ever a conflict between two U.S. states, our Supreme Court can hear that case first. And once the Supreme Court hears and rules on a case, that is the precedent that stands. Okay. Now we talk about checks on the Supreme Court. Congress can obviously pass laws. The Supreme Court doesn't do that, so Congress can pass a new federal law. Congress can start the amendment process, things of that nature. Congress can also change the number of justices on the Supreme Court, and ultimately Congress can also create more courts. So again, there's kind of a variety of checks that Congress holds on the Supreme Court. We have 9 Supreme Court justices. Okay, so getting into Fed 78, again, the anti-federalists were really concerned about this power, so to speak, that's held by the Supreme Court, even though, again, our Constitution says very little about it. But in Fed 78, again, remember, Fed 78 is about judges. It's one of the last Federalist paper you have to know is 78, big number, judges serve for life. They're oftentimes old by the time they are done. But in Fed 78, Hamilton makes some very important arguments. He says that our Supreme Court will be impartial from politics, okay, that because they are appointed, they are not elected, they serve a life term, those things insulate them from the factions or the party politics that we know of modern times. He also argues that the Supreme Court, or the judicial branch as a whole, was the least powerful of the branches because they did not control the purse, unlike Congress and the president who controls the money, and nor do they control the sword. They don't control an army like the president or Congress, therefore they cannot make war. He says their job is simply just to review what laws mean, and because of that they would hold no threat towards the liberty of individuals. Now, I think we can all think over the course of time, our Supreme Court in the 1800s is the same body that said that racial segregation was okay on the basis of separate but equal. And that might be a limitation of liberty of those certain individuals, in that case people of color, African Americans. But it's also our Supreme Court who later ruled that racial segregation was unconstitutional because it was a violation of the Equal Protection Clause. So again, Hamilton maybe didn't see those issues coming up, but he would have argued in Fed 78 that because our judiciary, our court system, and our Supreme Court, all they do is interpret the law. They don't make those laws, so they can't really take liberty away from people. Okay. We could use another kind of example with that too. We talk about the Roe v. Wade case that establishes the women's right to privacy and ultimately the ability to obtain abortions and that type of thing, and that being now overturned by a new, more recent case. So again, Hamilton maybe didn't see that coming, but his argument in Fed 78 is because the court does not make laws, nor do they enforce laws, therefore they could not threaten individual liberties. Okay. Getting into our early Congress, there's a lot of things here about, kind of our structure of the court. You can see there on the right-hand side, kind of that stepladder of courts. Again, district courts oftentimes will hear cases first. Either party, the defendant or the our defendant. Sorry, lost my train of thought temporarily, or the prosecuting party, right? At the district court level, if there's criminal charges brought, the district court will hear that case first. Now, if one of the parties feels like there was some sort of error in that case, or if they simply disagree with the ruling, they can appeal that. And the next stop would be like a federal circuit court or a U.S. Court of Appeals, where, again, there is no trial. Okay, once you get out of that district court level, there are no more trials. There's just lawyers that argue on the basis of if they feel there was an error in the lower case. And these appeals courts, they have the choice to hear cases or not. They don't have to take any. So like if we talk about this structure, the district courts by far hear the most cases. The Court of Appeals hear less, okay, and the Supreme Court hears hardly any. Like the Supreme Court takes maybe 100 cases a year on a busy year, okay? Again, we've touched on all of these things. Again, that presidents nominate and appoint judges to the Supreme Court and to federal courts. It's their way of kind of trying to hold a legacy and influencing how things might be done, interpreted for years to come, and it can hold a major, it's a major, way in influencing laws and such later. But, again, things that we've kind of already touched on here. All right, so getting into our last of our foundational cases, Little Marbury versus Mass, and we talk about early Supreme Court, United States Constitution's a very, very new thing at this point. John Marshall was one of our first Chief Justices, but not the first. The first Chief Justice, in fact, was John Jay, one of the authors of the Federalist Papers, But John Marshall will become a very influential Supreme Court Chief Justice in some of the early cases he has to rule on. So like McCulloch versus Maryland would have been a John Marshall case. Okay, but probably the most important one is Marbury versus Mass, and that's what we're getting into here. So again, background on that, John Adams, second president of the United States. Again, the same John Adams that helped write the Declaration of Independence and was a very important politician early on in United States history. He only serves one term, he gets voted out, right? So Thomas Jefferson beats him in what becomes the election, I guess it'd be of 1804. And that kind of also, the previous election, 1800, is going to eventually create the 12th Amendment. But there was a law passed in 1801 called the Judiciary Act of 1801. And this has to do with ability of the Supreme Court to order federal officials to do things. So again, John Adams gets defeated by Thomas Jefferson in that election of 1804. And when that happened, John Adams obviously knew that he had been defeated and such. And so he's sitting up late at night, and John Adams, like a lot of politicians, was kind of a egotistical guy, I guess you could say. And he was kind of an egotistical guy. And so he's sitting up late deciding, well, what can I do? I'm sorry, I got some names wrong here. So this is election of 1800, that's my bad. But nonetheless, okay, it's irrelevant. Jefferson is going to defeat John Adams when John Adams runs for re-election. John Adams decides, what can I do to really cement my legacy? And so he sits up late into the night and he fills out all of these judgeship appointments. These people who receive these last-minute judgeships were known as the midnight appointments or the midnight judges, okay? And again, these are some of John Adams' closest political allies and people he wanted to get onto the federal courts because, again, life terms and such, they would have some influence going forward. And so one of these individuals who received one of these last-minute judgeships, his name was William Marbury, okay? And so John Adams is out of office. Jefferson is now in office. He's been inaugurated. He names James Madison as his Secretary of State. Marbury's commission never got delivered, okay? So he was awarded whatever judgeship position, and it never got, it never went through. Thomas Jefferson more or less told James Madison, do not issue these judgeships. John Adams is no longer president. Therefore, these these judgeships, they are null and they are void. And so Madison, takes the lead of Jefferson on that and decides, well, yeah, okay, my boss, the president's telling me not to deliver these, so I'm not going to deliver them. And with that, what'll happen is, and John Marshall was also one of these midnight judges too, which is interesting. But what happens is when Marbury does not receive his judgeship, he is going to ask the Supreme Court, more or less, to force James Madison to deliver it. And so it goes to the Marshall Court. Again, John Marshall, who was, in fact, one of these midnight judges, and becomes a super influential guy, he's going to have kind of this big case on his hands that becomes known as Marbury versus Madison, where he's going to have to examine did the court have the power to force James Madison to deliver this judgeship. So in this Marbury, and there you see the picture of the William Marbury, the handsome guy there. John Marshall has a couple of questions to answer. And again, William Marbury and a handful of others did not get their commissions delivered, so they have some really upset people here. And the questions are, did these appointees, did they have an entitlement to their commissions? And if so, can those commissions, can they be delivered? Can the court force Madison to deliver those commissions? And so they challenged under what's called the writ of mandamus, or mandamus, depending on what you talk to or who you talk to. A writ of mandamus would have forced James Madison to deliver these commissions. Okay, and that was a part of the Judiciary Act of 1789 that would have, been signed into law, I suppose, when Washington would have been president. And so Congress, there had been some things happening there, but the Judiciary Act more or less could have forced a writ of mandamus, to be issued to James Madison, thus forcing him to deliver these commissions. And so ultimately what Marshall is going to rule, he says a couple things. And the big thing is he says is that yes, William Marbury is entitled to his judgeship. Okay, he has the commission is not quote unquote null and void. It was still signed when John Adams was president, therefore it should still be honored. According to John Marshall, the bigger issue was that the court did not have the power to issue a writ of mandamus, and they did not have the power to force James Madison to deliver it. And so with that, John Marshall and the court ultimately rules that this portion of the Judiciary Act of 1789 that said, talked about these writs of mandamus, that it was unconstitutional. And this is going to establish the Supreme Court's power and the federal court's power ultimately of judicial review. And judicial review was not a new thing. It was written about in Fed 78, right? It was something that Hamilton argued would be an important power of the court, is to rule on the constitutionality of laws and actions. But nonetheless, this case, it's going to establish that precedent, that power, so to speak, of the Supreme Court to rule on the constitutionality of laws. And we call that principle judicial review. And so Marbury versus Madison ultimately probably becomes the most important Supreme Court case ever heard in U.S. history, because it now formally establishes the Supreme Court's power to rule on the constitutionality of laws. And ultimately, it will expand the power of the Supreme Court to interpret the Constitution, and it cements the judicial branch as a quote-unquote a co-equal branch with the legislative and executive branches. And again, that's basically the only true power the judicial branch has. They rely on the executive branch to enforce decisions. They rely on Congress to write laws. And all the Supreme Court and our court system can do is rule on constitutionality. And so it kind of levels the playing field, if you will, between the three branches. So again, two of the big foundational things here are Fed 78, a Hamilton paper, importance of independent judiciary. How do we do that? Is with life terms. We do that with life terms is a big one. And by not giving them and kind of insulating them from politics, right? So if they make a decision that's not popular, they cannot be quote unquote fired for that. And then we have Marbury versus Madison, which ultimately will establish the court's power of judicial review, that can be used to overturn actions of the executive or legislative branches. Okay, so again, those are two big things here. Kind of getting back into that organization. Again, courts are going to hear on in general, whether you're talking a state court, a federal court, whatever, courts like trial courts, whether it's a federal district or like a state or municipal court, there's two types of cases they hear. One's the criminal variety, where somebody has violated a law, okay, whether it's a state law, a federal law, whatever. And you have civil law, and civil law are those that ultimately kind of have to do with groups of people if there's ever a spat. So something like a divorce could be a civil thing. Breach of contract could be a civil thing. But you're not talking about criminal laws. A civil law often has to do with some sort of spat over money or property. Okay, whereas a criminal law is an individual has violated something criminal in nature: murder, drug dealing, human trafficking, you name it. And so then the government becomes a party to that case in the sense that they have to prove guilt of the defendant. Okay. Again, we're going to kind of leave state courts alone. I feel like we've talked about these. Again, our layering system of our federal court. We have federal district, again, original jurisdiction. Our intermediary courts, our federal courts of appeals, or what I like to call circuit courts. And then we have just one Supreme Court. And since 1869, we've had 9 justices sit on that court. And again, that number could be changed if Congress decided it was necessary. Here you see a map of the quote unquote the federal circuits. So you can see that North Dakota here is in circuit number 8. And if there was ever a case that was appealed from the federal court in Fargo, if it was appealed within the 8th Circuit, that case could potentially be sent to the 8th Circuit Court located in St. Louis, Missouri. And as an appellate court, that 8th Circuit could say either A or nay to taking the case, as in they do not have to. If you look at this map and you're thinking, well, a lot of these cases, okay, again, I mean, most of the cases that the Supreme Court hears come from the state level. They come from like state Supreme Courts, so to speak. And again, North Dakota has a state Supreme Court. It's the highest court in the state. But if you're thinking, well, which federal circuit does the Supreme Court deal with the most as far as cases? Well, ding, ding, 9th Circuit, again, home to California and some very popular or populated states. Okay, but anyways, kind of moving along from that. Again, Supreme Court holds a lot of, they dictate a lot as far as which cases they hear. Again, they're usually only going to take cases that are of high national priority, those that they believe are serious questions of the Constitution and things of that nature. And again, they take very few cases. There's nearly 10,000 a year on average that are appealed to the Supreme Court, and they might take 100, or as the notes say, they might take 80. Again, over the course of time, they've taken less and less cases. Now, how does a case get to the Supreme Court? So we have what's called the Rule of 4. We have 9 Supreme Court justices. If 4 of those justices say, yes, let's take the case, what is then granted is called a writ of certiorari, excuse me. And all that means is that lower court, so let's say there's a case coming out of the 9th Circuit with California. There's a party, whether it's the government, whether it's individual, they appeal the case to the Supreme Court. If the justices look at it and 4 of them say, yes, let's take this case, the court will send for what is called for the writ, so to speak. And that writ would then require that lower court to send the information on the case to the Supreme Court, where they could still either decide to take it or not, but it would at least require that lower court to send the information, to send the briefs on the case. If the Supreme Court takes that case and they rule on it, that decision establishes what is called a precedent, and that precedent acts as a basis for future decisions of the court. If the court says we're not going to change anything, we then have what is called a stare decisis, which means we're going to let the previous decision stand, that we're not going to change anything, and we're going to let a previous legal decision take precedent here. Okay? I know it's a lot. Again, Supreme Court or an appeals court in general, they have 3 different ways they can rule on the case. Ultimately, the way the court rules is called the majority opinion. So like we have to know our, Gideon versus Wainwright and Schenck versus the United States and Tinker versus Des Moines. And we talk about how did the court rule. That's called a majority opinion. And again, that's a majority. So you have to have 5 of the 9 for a majority. Of that majority, sometimes there will be judges that will agree, but they'll agree for a different reason. They agree with the majority, but for a different reason. We call that a concurring opinion. And then you always have those that disagree, and we call that a dissent. The judges that identify with the majority, there's a big brief or a reasoning for why, literally an opinion. It gets written up, it gets put in legal dictionaries, and that is oftentimes what is referred to when looking at other cases. A concurring opinion, if you might have 2 or 3 judges of that majority who agree but for different reasons, kind of to get their official take on the law, they write what's called a concurring opinion, where they write, yep, we agreed with the majority, but not for these reasons, for these reasons. And then you have the dissent, which is those who don't agree with the majority. Again, again, we want to insulate the court from politics, but again, we see this term again, this amicus curiae brief, where sometimes interest groups or those who are not party to the case, they will actually write a letter to the Supreme Court attempting to influence how the Supreme Court will rule. So again, with the development of interest groups over the course of time too, it's become harder and harder to really truly insulate our Supreme Court from politics. Here we just see some flow charts on how cases can move through the system. I'm going to kind of skim that really quick. And here's a good one about the Supreme Court. But getting into just a couple of our 2 last terms, and we talk about judicial restraint and judicial activism. Okay, so judicial restraint is the idea that Supreme Court justices or federal courts, state Supreme Courts, whatever, that they should not use their power to change legal precedents. Okay, and we call that judicial restraint, that they are restraining from using this judicial power to ultimately change a law. Again, because it would be argued that it is the job of our legislative branch and our executive branch to create and to enforce laws. It is not the job of the court to do this. And so they would, those critics would sometimes ask for what is called judicial restraint, and the idea that, especially the Supreme Court, that they should be cautious in overturning previous laws because that's not really their job, okay, and that our legislative bodies who have been elected by the voters should be doing that for the will of the people, because the judicial branch isn't really for the will of the people. The judicial branch are officials who are there to interpret the law. And so we call that judicial restraint. Judicial activism, though, on the other hand, are those who say, yes, the court at times, they should use their judicial powers to ultimately, shape how laws are enforced and what that is. That sometimes Congress might make mistakes, our executive branch might make mistakes, and so that they should use this judicial activism to change how things are done, right? That at various times, maybe there's been groups of people, African American civil rights movement, who maybe have had, at the state level, especially during like the Jim Crow era South, that there was laws being passed that were oppressing them, and that the Supreme Court had a job in changing that. And we talk about like the Brown v. Board of Education case, and that becomes a groundbreaking one and a good example of judicial activism. Okay, so those are kind of our things. I know really quick here, we kind of already hit on some of these things. These are just some limitations and some checks on the court. Again, how Supreme Court judges get their job and what that is, and Congress's role in that. So I would kind of come back to those. But yes, again, just really quick, hope you guys all have a good snow day. We will hopefully see you back in class tomorrow.